elections 2012, a new cabinet secretary comes in and he says, let's get to the bottom of this. So I was appointed to chair a task force on to investigate matters of anti-doping in 2013. At the time of appointment, I was doing something at the Université Libre de Kigali. So I just got news of that while there, came back. I found a wonderful team of 12 people I had never worked with before. 5 lawyers, 2 medical doctors, 1 from Nakuru, another one from Mombasa, sports officials, and from the AG's office, from the ODPP, from the sports ministry, from everywhere. 12 of us. After the first 2 meetings, Honorable Chair, we gelled. We worked on focusing on the objectives. We worked on the objectives, produced a report. The report was received by the government. It was very well received by the international community. The government acted on it, and as we sit here, Honorable Chair, we have an anti-doping law in place. We have an anti-doping agency in place. The international community is no longer doubting our sports persons.
Okay, thank you for those examples, Professor. I'm just thinking about the rule for students to wear suits Monday to Friday. And I'm just wondering whether, when you think of a university student, you're thinking of blue jeans and T-shirts. I mean, that's the life of a student. Now, if they are wearing suits, and nothing wrong with that, but have you considered those who may not be able to afford the suit Monday to Friday? Have you taken care of them?
Oh, yes. Honorable Chair, that question came up in our discussions, especially at Mount Kenya. And it was in that light that the students said, okay, sir, we think the idea is very good, but then some of us may not be able to afford 5 suits at a go. Meaning, if I have 1 suit and I'm wearing it 5 times a week, after 1 month, it will no longer look like a good suit. So kindly allow us to implement this in a progressive manner. So we said, okay, how do we do it? Then they suggested, we were discussing like in this semester to start the following semester. So they suggested, well, for the following semester, let us make it 1 day in a week. So we said, okay, Monday. The semester thereafter, we make it Monday and Tuesday. So we did it progressively to accommodate those who would have challenges. Days, the Honorable Chair, it is in the admission letter. It's part of the requirements.
That you must come with
yes.
Suits. Okay. My last question to you, Professor, and I'm sure you have thought through the role of a Chief Justice. So if we nominated you to be the Chief Justice, please tell the Commission what you do the first 3 months, immediately, short term, maybe 1 year, and then long term.
Honorable Chair, the first thing I will do after I come in May next month is to work on mending relationships between the judiciary and the other arms of government. For me, that would be the first agenda on my list. The second agenda, Honorable Chair, is to build allies, to take the judiciary to the people. So far, the judiciary has done a lot. There are very wonderful reports about this and that and percentages, but somebody in the village in Magarin doesn't know about that. Border riders gathered somewhere in Kakamega don't know about that. So my next agenda would be to take the judiciary to the people. What am I saying in practical terms, Honorable Commissioners? We have professional bodies here. We have the Kenya Medical Association. We have the HR professionals. We have this and that. I want the judiciary to be present at each of their annual meetings. We get a slot and just tell them about the judiciary, what we do. All the professional bodies, and all of them hold annual meetings. The second group, Honorable Chair, the Kenya Association of Manufacturers. We read about them there, we meet them in court, but they are also human beings. They are people. I would want us to have a session with them, a structured meeting with them, just to tell them about the judiciary, what the judiciary does, and all that, so that they also can, buy into the judiciary, accept it as their own. Honorable Chair, we have trade unions in this country. We hear about them when there are disputes in court, but I would want us to have occasion when they are having their normal meetings. We send there, say, Commissioner Koske, to go and talk to them about what the judiciary has done, what the judiciary is doing. Honorable Chair, we have law schools. At the moment, our relationship with law schools is not formulated at all. With respect to law schools, Honorable Chair, I'll want about 3 forms of engagement. Number 1, we get all employees of the judiciary who have postgraduate degrees to offer to teach at least one course at the university. So if someone is CPA, Dr. So-and-so in finance, let the person identify the university where the person can teach at least one course in finance. I want this magistrate in Homa Bay who has a master's degree to volunteer at least 3 hours to go and teach. Let us be able to interact with other members of the university system so that they are also able to feel the judiciary. Honorable Chair, at the moment, law schools have better courtrooms than the judiciary. And this is because the moot courtrooms are molded along the lines of the courts at The Hague. Beautiful, networked, and so on. Added to that, courtesy of the Council of Legal Education, each law school has some kind of area of focus or specialization. I would want the judiciary to enter into some kind of structured engagement with each of these law schools so that using their ports of strength, they are able to develop moot court sessions, which would then eventually be televised. We have very many TV stations. So we can have, for example, Citizen running a program on family law offered by Catholic University. We have NTV running a program on environmental law from the University of Nairobi. We have KTN running a program on communications law from Daystar University, and so on. But then again, weekly programs. When we were growing up, we used to hear of Vioja Mahakamani. I would want us to improve on that aspect of Vioja Mahakamani so that we use this and through the linkages with the universities to be able to sell the message of the judiciary to the law schools. I'm thinking about these border riders in very many centers. They have a stake in the judiciary. I would want us to have set up some kind of way in collaboration with the NGOs to be able to reach out to the border riders, to be able to reach out to these traders at open air markets, to be able to reach out wherever, so that they also get to know about the judiciary. And I have thought through this, Honorable Chair. I would want to package 4 points. Number 1, how does the judiciary work? Number 2, alternative dispute resolution mechanisms. Number 3, obeisance of court orders. And number 4, corruption. If we're able to package these 4 points, which can be packaged in a 15 to 20 minutes presentation, sell it to our border riders, sell it to people everywhere. they will be able to move with us. They will be able to co-own the judiciary. They will be able to feel the judiciary is theirs. Honorable Chair, I think in terms of one of the things I would do is to try and make the judiciary people-owned. I want the people to own the judiciary. Once we get them to own it in that manner, where they have a lot of information about it, where they are able to associate with it, where they are able to feel what it does, then should we want to know about corruption in the judiciary, they will tell us, because they are the people. We live amongst them. They know us. Should we have challenges with obeisance of court orders, they will help us. In the same vein, Honorable Chair, I did talk about mending relationships, but I didn't go further. Allow me half a minute to do that. I'm alive to the fact that in Parliament, we have specialized parliamentary committees. One in charge of justice and legal affairs, finance, what. But in my thinking, each member of Parliament has a stake in the judiciary. I would want us to reach out to every member of Parliament. We have a category of representatives called women representatives. I would want the judiciary to engage with that category. So when they go back to their constituents, they are able to sell the message of the judiciary. We have senators, Honorable Chair. I'm not talking about committees at this point. I'm talking about senators as representatives of various counties. I would want us to engage them so that as they go about their duties in their counties, they are able to sell the message of the judiciary. We have the kinds of governors. That is at an official level. We have the MCAs. These MCAs also have annual conferences. I would want the judiciary to be present at those conferences every time they are holding a meeting. There's an association of speakers of counties. When they are having their meetings, I want the judiciary to be there. So that way then we carry the judiciary to that place. Now, staff. I said I bring out the best in others. Honorable Chair, with respect to staff, I have 2 to 3 things to say. Number one, the question of transfers of staff where small families are hurt. Employees of the judiciary are as well entitled to the protection under Article 45 as any other Kenyan. I would want us to have a serious review of the transfer policy and ask the Kenya Magistrates and Judges Association to tell us how they want it done. It is their thing, let them bring in that. But then aside from that, we have other employees of the judiciary. I would also want to hear from them how they want it to be done. We get it from them and implement something that we are all comfortable with. Again, still on the staff, Honorable Chair, I want some very serious engagement with staff development under the Bangalore principles. There's talk of competence. I want to improve the competences of all staff of the judiciary. How do I want this done? Through short-term seminars, exchange programs with neighboring counties. The government of Kenya usually receives some scholarships from Japan, Commonwealth, where, as Chief Justice, I will want to lobby for a minimum of 15 scholarships annually devoted for members of the judiciary. So that when we then get them, we have a committee that would have set out rules for allocation, and then they are allocated fairly. And with time, we help improve ourselves. Honorable Chair, maybe let me stop at that point.
Okay, just one short follow-up question, Professor. You have talked very well about partnerships, with universities, with other Kenyans and all that, and that is all good. But if Kenyans are looking for an effective judicial system that works, Professor, give us 5 indicators. You are also a researcher. Give us 5 indicators that you would think about that define an effective judicial system. Just 5.
Honorable Chair, an effective judiciary would be one where people can take their disputes and the disputes are resolved very quickly. Quick resolution of disputes. Mm-hmm. An effective judiciary would be one where when people walk in, they are treated humanely. That welcome. An effective judiciary would be one that is able to effectively communicate with Kenyans. The judiciary exercises authority that is given to it by Kenyans. There must be some way of effective communication. An effective judiciary, to me, will be one where those working in it feel comfortable to work in it, feel proud to work in it, look forward to waking up to go and work. An effective judiciary, to me again, in terms of accountability, is one where each member can say, I made a contribution. I have done that. I have done this.
Okay, Professor, thank you very much. I will now request the acting CJ to continue with the questions.
Thank you. Under the instrument internally that we call the Sustaining Judiciary Transformation, which we see as our true north inside here currently, we have initiated a revamping of the central administrative structures within the judiciary. In your preparation for this interview, you must have come across that. If you did, I will continue to use the word discuss. I'm not a professional interviewer, but if you don't like the word discuss, you could use any other one or ask one of the rest of us to tell you the right word. So I'll ask this professor. Please discuss the rationale for that significant reorganization that we have done under the Sustaining Judiciary Transformation. Tell us what the objectives are and how you, as our Chief Justice, will enhance those ones or change them to improve the way we do things in the judiciary.
Thank you, Honorable DCJ. In terms of rationale, it is standard practice that any organization should periodically look inside at itself to find out what is working, what it's doing, what it's not doing well, reflect on it, and propose changes. The rationale of that reorganizational structure is to enhance efficiency in the provision of services in the judiciary. Now, in terms of specific objectives, one of the objectives is to one of the objectives was to do a kind of a job analysis to find out whether there is duplication, whether there was reason for mergers, whether there's need to designate jobs differently. The other one was the grading classification, whether the existing grades are serving the judiciary well, or whether there's need to improve on the grading system. The third one, I think again driven by the same thing, is to try and see if there can be some way of worker satisfaction within the judiciary, so that you don't have a situation where a cleaner is earning more than a resident magistrate, or say an accounts clerk is earning more than a judge. So, classification of the jobs, job analysis, and trying to infuse efficiency. The Honorable DCJ asks me, what would I do differently? I have looked at the proposals. I would say I'm in agreement with the proposals. I would want to give them a run the first 3-4 years, and that would be time to review again, especially when we are reviewing the next strategic plan. For now, this has just been done. A new strategic plan is about to be rolled out. Let us move with them to the new strategic plan.
Thank you, Professor. What about the same description, but in the leadership structure? What have we just revamped in the leadership structure? That was administrative leadership under SJT.
Yeah, in the leadership structure, I did not see much, but I would want to say that that is something I would want to look at what there is in order to see whether it's serving us or if we need to improve on it. I just want to mention very quickly, Honorable DCJ, that I did see the Commission has committees it works with, and that is very, very good for governance purposes.
Sorry, Professor, I'm talking about the judiciary, not the Commission.
Yeah,
the judiciary, the leadership structures. Professor, as our team leader, as CJ, I doubt you would succeed alone. Maybe you would, but I would have thought that you would work with teams, which is what you said earlier in answer to questions raised. You said you are a team builder. And the latest instrument we have in here is the formation of some central leadership structures. If you haven't encountered them, that's okay. Then we go to the next one.
I have not encountered them, Honorable DCJ.
Thank you, Professor. The judiciary is also in the process, the judiciary, not the Judicial Service Commission, is in the process of implementing a robust alternative justice system. We just launched not too long ago what we call the AJS policy, the Alternative Justice System Policy. Professor, this is the question flowing from that. What, in your opinion, is the relationship between alternative justice systems and the judiciary?
Thank you, Honorable Chair. Alternative dispute resolution systems are recognized under Article 159 of the Constitution, where the Constitution commands that they be given a place. The jurisprudence from our courts has also been very emphatic that where mechanisms for alternative dispute resolution exist, they should be exhausted before one runs to the court. So in terms of where they stand in relation to the judiciary, that is already in the law. However, implementation is the challenge. And I think this is also one area I need to mention that I would want to work on. At the moment, we have the court-mediated
dispute resolution mechanism.
Dispute resolution mechanism. But then, who are the mediators? What qualification must one have to be a mediator? Who regulates the mediators? So one of the things that I would want to really move on very fast is to have some form of regulation of these mediators, some form of regulation of persons involved and participating and contributing to alternative dispute resolution.
You don't think we have that in place now?
Pardon me?
You don't think that we have that in place right now?
I have seen something, but I have not really seen regulations like if a mediator misbehaves, this is the body that will punish them. At least in Uganda, mediators are part of the court. Judicial officers are trained to be mediators and they are part of the court system. Here, we have very many mediators out there. We have very many people calling themselves certified public mediator. They are not under the control of the judiciary, but I'm looking at a situation where we can bring all this under one roof so that there's some form of control and coordination. Honorable DCJ.
Thank you, Professor. And that would, of course, be your way of improving AJS, so to say. Let us go to the second one. I have 4 broad areas to cover within 30 minutes. Now, one key component of courts' institutional structure is that the judiciary is organized as a hierarchy, which has statutory authority. That being so, that hierarchical arrangement can cause both problems and both opportunities for judges, for magistrates, for all of us in the judiciary. Now, from that statement, I ask this question. What is the administrative and judicial structure of the judiciary? How do those structures interrelate? Is that hierarchy created by law important? Is it important at all? Or is it something that is now due for review?
Yeah, thank you, Honorable DCJ. Indeed, the judiciary is hierarchical. We have the Supreme Court, Court of Appeal, High Court, Employment and Labor Relations Courts, Environment and Land Court, each with a designated head who then coordinates the activities of that court in terms of opportunities. It makes it very easy to manage affairs within a given court. Even as I say this, at the various court stations again, there is an administrative structure with a designated head, and that is good for coordinating activities in those court stations. Now, Her Honor asks, does that pose any problems? In terms of problems, I wouldn't want to look at problems. I would want to look at a situation whereby there is some kind of forum where the leaders of the various courts can come together and discuss matters relating to their courts, matters relating to the judiciary in general, with a view to having a smooth functioning of the judiciary. I think that's all I can think of on top of my head right now, Honorable DCJ.
Thank you, Professor. The Judicial Service Act contains provisions for both the judiciary and the Judicial Service Commission. Chapter 10 of the Constitution of Kenya 2010, under the heading The Judiciary, establishes the Judicial Service Commission. The Chief Justice is the chair of the Judicial Service Commission, and the Judiciary Chief Registrar is the secretary of the Judicial Service Commission. With that background comes the question: is there a demarcation between the Judicial Service Commission and the judiciary? In case your answer is yes, what is the importance of any such demarcation?
Honorable Chair? Sorry.
Yes, let me just finish. In case there is no demarcation, then give us the pros and cons of that situation as given in the Act and the Constitution 2010.
Honorable DCJ, there is a difference between the Judicial Service Commission and the judiciary. The heading of Chapter 10 is Judiciary, but under that, then we have these two bodies. However, I think it's Article 160 that then goes ahead to define the judiciary to mean something more specific, excluding the JSC. In terms of functions of the JSC has very specific functions. And my understanding of those functions is that the JSC is supposed to be like the policy giver, the overarching body, because then it does recruit judges, it does discipline judges, it does recommend for appointment persons deemed to be fit to hold those offices. It also has an obligation to promote the independence of the judiciary. Now, what is generally understood as judiciary is that part that is then made up of the court system. And then her ladyship asks, what is the importance of that demarcation? The importance of that demarcation is contained in Article 160, to my understanding. Under Article 160, judicial officers are supposed to make decisions without looking over their shoulders. Judicial officers are supposed to make decisions considering only the Constitution and the law. Now, that then bars the JSC from interfering with the decision-making of the judicial officers. So the JSC, in terms of architecture, then sits there as the apex body, guiding whatever is going on, but not interfering, number one, with the day-to-day operations that are under the Secretary of the Judiciary, and number two, without interfering with the day-to-day management of the courts.
Thank you, Professor. Those are just two of the roles of the Chief Justice. What other roles would you, as our Chief Justice, have to play institutional leadership roles?
Honorable DCJ, the other role is to chair the National Council on the Administration of Justice. The other roles are kind of overlapping, like swearing in the president, deputy president, swearing in advocates.
Those are under the Chief Justice.
Yes.
So let us remain with the one you have already given, the NCAJ.
Yes.
Professor, as chair of NCAJ, what would be your priorities?
As chair of NCAJ.
And as you tell us your priorities, you tell us the challenges they currently face and your solutions for those challenges, please.
Very well, Honorable DCJ. The NCAJ brings together very many actors at one table. These actors come with their own challenges from their institutions. But the whole point here is to try to coordinate the administration of justice. Now, the challenges that then bedevil NCAJ will be institutional, coming from the respective institutions themselves. For example, if the prisons has challenges with motor vehicles for transporting remandees to court, we can discuss it at NCAJ, try to work out solutions, but unless the transport situation is improved with the prisons, we shall have either the remandees not showing up for their mentions and court appearances and so on. The ODPP, something common to all is the one of digitization, Honorable DCJ. These institutions are at different levels of digitization. So if we talked of having virtual mentions, some will be able to log in, others won't be able to log in, and that then affects the administration of justice. So one of the main challenges that I see is one of digitization, and that is one that I would want to really impress upon participants, or rather members of NCAJ, to prioritize in their various institutions so that then the ODPP is able to participate in court hearings from the offices, the prisons, the police, and so on.
Professor. Let's go to the next one. A prominent jurist once asked, I quote, "How are we judges to deal with political problems that have taken a legal character?" Can you address that question? And cite relevant examples to us. 1, 2. What challenges, if there are any, that you feel the increasing litigation of politically charged issues through our courts poses for the judiciary?
Very well, Honorable DCJ. Politics and the judiciary. The first case that comes to mind is Madison versus Marbury, in which the Supreme Court was called upon to make some decision, and the court said, we leave it for the political players to do their part. Honorable Chair, today is Thursday, I think beginning of the week, or end of last week, we had a decision in the case of Ndi versus the AG on the BBI. And the court said, look, we cannot interfere with the proceedings going on in the county assemblies and parliament, but we can wait to look and interrogate the final product. I think that way the courts are able to navigate the political landscape, number one, by exercising restraint and allowing other arms of government to do what they are supposed to be doing. But at the same time, if called upon, now check whether what was done in line with the Constitution and the law. Now, her ladyship asks, what challenges, the question is, what challenges that process?
To the judiciary?
To the judiciary, oh, lots of challenges. Honorable Chair, I was watching an interview by the CJ of South Africa, Mohoeng, and he said, where the three arms of government are working very well, there will be tensions. But the whole point is, it's important that they talk to see how to ease the tensions. With respect to the judiciary, when the judiciary, say, declares an action or a law as unconstitutional, then it's looked upon as being activist, as interfering. And it is annoying. Naturally, all of us like appearing like we are well, we are good, we are doing the right thing. When we are rudely reminded that what we have done is bad, it injures one's ego. So then, through such actions, where the judiciary is actually doing its work, it can be quite injurious. 2 days ago, we have this decision on the CAS, that Cabinet Administrative Secretaries. I haven't yet had the Honorable Attorney General comment on it, but that is again a decision that is backed by law, and yet one that is bound to rattle feathers that would draw anger against the judiciary. So yes, in performing its duty, the judiciary will be looked at as interfering with the other arms.
Let us complete that discussion by hearing your comment on judicial legislation. Can the judiciary legislate?
Honorable DCJ and Honorable Commissioners, the Constitution is very clear. In creating the three arms of government, there are functions. Allow me to quote this long-serving former DCJ of South Africa, Dihang Moseneke, who says, when we talk of separation of powers, number one, there must be separation of functions. Number two, there must be separation of institutions. Number three, there must be separation of persons. So you don't have a person serving as a minister and at the same time serving as a judge. And number four, the judiciary must focus on what it's supposed to do. Now, the question whether the judiciary can legislate or not, the straight answer, first of all, is no. But then now, generally, it is also said that in the process of legislation, the legislature may not be able to take care of minute details that are bound to arise in the course of implementation of a given statute. There then, the judiciary is called upon to interpret. In the course of that interpretation and clarifying things, one may then be said to be legislating, but strictly speaking, no.
Is there such a thing as judge-made law? And in relation to Article 20, Sub-Article 3, on enactments that impact the Bill of Rights and Fundamental Freedoms under Chapter 4, is the court not asked to develop the law to the extent that it does not give effect to a right or a fundamental freedom, and adopt the interpretation that most favors the enforcement of a right or a fundamental freedom?
Honorable DCJ, the courts are called upon to do that, but within the law. However, I also said that in the process of interpreting the law, in the process of giving clarity to the law, the courts are bound to come up with something useful which had not been foreseen by the legislature. I have in mind very quickly the case of Mitubel. For a long time, we talked about title to land, ownership of property, but we had never thought of the right to housing, and housing kind of standing alone even on land that is not yours. To that extent, the Supreme Court interpreted the law to give effect to the intents of the Constitution and to promote the rights and freedoms of the people. Now, strictly speaking, it is not judgment law, it is interpretation of the law.
Thank you, Professor. In 2020, the Supreme Court amended its instruments, the rules, the election petition rules, and so on and so forth, to enable it to better effectively discharge the functions or the mandate given to it under the 2010 Constitution. Would you like to mention a few of those amendments if you have come across them?
Honorable DCJ, I have not actively interacted with them.
Asante, Professor. Finally, from this end, when you come in as Chief Justice, there's an extremely important role that I was waiting for you to mention, but let's discuss it very briefly now, that you will perform. That of being the president of the Apex Court. You come in now and find judges who've been there since 2011. Yet, you are the first among those judges, and by the Constitution, you are the team leader. Okay. Please tell us what attributes that Professor has that will bring seamless cohesion in that court. 1, 2, make you the jurisprudential head, as you have to be that. And 3, to solve discomfort when once in a while it happens. What do you bring to the presidency of the Supreme Court of Kenya, Professor? And with your answers, I wish you well.
Thank you, DCJ. In terms of cohesion, I have worked in committees, with committees, I have headed committees. I believe I have the skills to build a cohesive team. In particular, I am a good listener. I encourage others to speak out freely and without fear. I consider the viewpoints of others. I consider concerns of others. I believe in consultation. I believe in giving each person an opportunity to do their best, to bring out the best in them. I have also learned over the years that as human beings, we also have our own weaknesses that we may bring with us to the job. Now, I have learned also how to help overcome that so that that does not derail what is supposed to be done. So, in terms of team building, being team leader, I would say I have the requisite experience gathered in institutions in Kenya and abroad. I have no challenge with that. Honorable DCJ asks about jurisprudence.
Jurisprudential head.
As the jurisprudential head, number one, personally, I have been a teacher of the law since 2010. So I can say I'm fairly well versed with the law. And I'm using the word fairly well versed with the law. In terms of building jurisprudence from the Supreme Court, and without any fear of contradiction, I want to say it here and now, that each judge will write their own judgment. I find it very useful when I'm quoting a case from the House of Lords to be able to say, Lord Atkin said this. I want a situation where our scholars, our students can be able to say, yes, according to Justice so-and-so in his or her concurring opinion, this person said this. Each judge will write their own judgments. Supreme Court, Court of Appeal. I'm extremely uncomfortable with these group judgments.
Thank you, Professor.
Also,
the final one?
No, I haven't finished.
Sorry.
There was the bit about resolving discomfort.
Yes.
Honorable Chair, if there is discomfort, I would want it to be laid on the table. What is the discomfort? What is the source of the discomfort? How does the discomfort relate to the work to be done at hand? Judges of the Supreme Court are employed to do certain things. So I want to know how that discomfort relates to the goals that have to be achieved. Then we discuss that, thrash that out, and move on and move forward as a team. Sorry, DCJ. Yeah.
No, that's fine. It is the attribute you have. There's discomfort everywhere, including in our homes. There's discomfort everywhere. So the question was what attribute you would employ to bring the discomfort back to comfort.
Thank you, Honorable DCJ. One of them is that of empathy. I would want to put myself in the mind of that discomfortable officer to be able to understand the discomfort from that person's point of view. And having so done, then engage with the person and hear the solutions that the person himself or herself prefers, then we'll pick out what works.
Thank you, Professor. And back to Professor Chair.
Thank you. Thank you, DCJ. Thank you, Professor. I will now request the Honorable Commissioner Judge Wasame to continue with the technical questions. Judge Wasame.
Thank you very much, Professor. Prof, I have looked at your very impressive CV, you have been at Catholic University, Mount Kenya University, Daystar University, KU, associated with Pwani University. You have also been in university in Zambia, Rwanda, Namibia, Botswana. I've also seen that you have done your LLB, LLM, and the PhD in the University of Nairobi. Any reason why?
This is NTV.
Sisi kama Kogalo team, saa hii game yetu imeenda class. Tunataka players wetu wapewe koti, ama namna gani?
Suit.
Wapewe suti. Tuxedo. Ivo. Goalkeeper kwanza tunataka friji wekewe pale kando.
Sofa set.
Double door. Tunataka kishika ball anaenda kwa fridge anachukua.
Ball gani hawakujangi kufunga wanakuwa wamesinda huko goalkeeper.
To get Kogalo, dial *811*850#. Skiza na Nation.
Wow, thank you for your time.
And do you have any question for us?
How juicy.
Juicy. Niko fiti maze niko fiti majamana mabenti wako fiti Juicy Pro.
Like every mom, you want the best for your child.
Happy birthday.
You make sure she knows the joy of sharing happy moments with family. And when everything comes together, you above all others will share the taste of success with her. Blue Band tastes like mama's love.
Salad vegetable cooking oil is the clear flowing secret to tasty meals. Buy 5 liters of salad vegetable cooking oil today and get 250 grams Zesta tomato sauce for free. Iflo kama salad. Salad vegetable cooking oil. Available in all cooking outlets countrywide.
This is NTV.
Of the holiday or 3/4 of the holiday looking for the family. There is concern that this court where you are going has that nomadic tendencies of moving its jurisdiction from one area to another area, and that legal practitioners, in fact one of the stakeholders told us that it is difficult to advise clients and litigants on what you can get from the Supreme Court. Combined by that nomadic tendencies of the court and the nomadic tendencies of professor, how do we trust you with the court?
Thank you very much. This is how you trust me with a court. What is being described as nomadic tendencies is nothing other than a wonderful exercise of the right to employment. An employment relationship always has an escape clause. An employee can be sacked under certain conditions. An employee can leave. So, all I have done is to exercise my right to employment, try to move around, gain experiences. And my friends from central Kenya usually tell me that a person who has traveled has seen a lot. I would want this commission to trust me to that extent that I have seen a lot through what the Honorable Justice Wasame describes as nomadic tendencies. Now, with respect to the jurisprudence from the Supreme Court, Honorable Commissioners, the Supreme Court is very young. I would not want to pass a harsh judgment on it at this stage. It is still evolving. I would say, let's give it a bit of time. The jurisprudence will settle with time. People will be able to know exactly what to expect when then they approach the Supreme Court.
Thank you very much, Professor. That's all for me. Thank you, Prof.
Thank you very much, Judge Wasame. And now I'll request the Honorable Commissioner Judge Bajaja to continue the questioning. Judge.
Thank you, Professor, and welcome, Professor. I just want to follow up from a question my colleague, the Honorable Acting Chief Justice, asked you, and you answered that you prefer individual judgments. But there are circumstances where you as the Chief Justice will want one single unanimous joint judgment. Can you tell us what kind of circumstances this could be?
I can't think of any at the moment. All I can say is that even if it's a single unanimous, then it should be indicated so. But that should be the exception rather than the rule. Currently, the rule is a joint judgment.
What I want to know is what are these kind of circumstances that you as Chief Justice, you will tell your brethren and sisters that colleagues, let us give one single judgment. What are those kind of circumstances?
I could think of interlocutory applications. I could think of, where applications for certification for an appeal, where we have at least two judges sitting to decide on that. I'm unable to think of any other specific circumstance.
Okay. I've been asked, one of the tasks I've been asked is to look at your writings, and I must say I am impressed by what you have done. You have done scholarly writings. First one is an application of an article on the presidential election petitions. You have also been involved in international decision making, which is important. An article on international sports. You have also written submissions, and you have published a book on judicial review. So I want to ask you just, and they're all good, and it is a credit to your learning that you have been able to combine both the law and your interest in sports. You have been involved in international decision making. Can you just give us what important lesson in terms of international proceedings that you would come with to improve case management and case flow? Maybe just give us two examples.
Yeah, thank you for that, Honorable Commissioner. Indeed, I participate in international decision making at the Disciplinary Committee of World Athletics and at the Ethics and Disciplinary Committee of the International Weightlifting Federation. In what we do there and what I think the kind of experience that I come with in terms of case management is that when a dispute is registered, we have a secretariat akin to a registry that registers that, asks for additional documents where necessary before a panel is put together. Once a panel is put together, then we meet, the materials are shared out. Then we meet first as a panel to discuss the material, to identify areas where we need clarification. And thereafter, we invite the parties. And Honorable Machenja, I'm glad you asked this, because again, this, we do it virtually. Like the one, for the one I submitted, the Russian athlete Bakulin, he was sitting in Moscow. The secretariat is in London. I was sitting in Nairobi. My other colleague was, there was another colleague in London, another colleague in Belgrade. Then there was a specialist witness in California. The advocate was in New York. Then there was another witness in Australia, and it was quite interesting, and it's quite interesting bringing the whole world to a court session, irrespective of the varying time zones. Now, after we hear the parties, then one of us is asked to draft the opinion. Within a certain time, it is then circulated for input by the others. And let me also say that at that level, the opinion is actually a unanimous one. We are not required to write separate opinions. Now, after we circulate and agree on the final draft, then it's brought for signature, submitted to the secretariat, who then publish it.
Okay. What I want to know is, what are your strategic, because you are aware, although in the last 5 years we have made tremendous efforts in reducing backlog, what are the strategic interventions you would make to deal with the issue of backlog, particularly given the COVID situation that has affected delivery of justice? Just give me 2 strategic interventions.
One of them is where I started. Sorry. Let us talk to Kenyans. Let us educate them. Let them be able to take a conscious decision whether they want to come to court or they want to avail themselves of the ADR. Okay. In the process, we reduce the people coming to court. That's number one. Number two, I mentioned about a 4-point agenda for sharing with the public. One of them is, and the last one was corruption. If we are able to sensitize our people on the ground about corruption, so that they are able to make noise, able to blow the whistle before the corruption takes hold, then we shall have very few people appearing in the anti-corruption courts. We reduce the backlog there. Then, of course, thirdly, is the enhancing the use of ICT in terms of court management and so on. Okay.
One of the books you have written on is on judicial, on administrative law, and a book on administrative law. Can you just briefly tell us how the Constitution 2010 has changed the landscape of judicial review? Maybe 2 ways in which it has changed the landscape of judicial review, pre-2010 and post-2010.
Yes. 2 quick ways I can mention is that, number one, everyone is bound by the Constitution, both private and public entities. I remember in 1993 when player Odumbe sought judicial review because the International Cricket Council had banned him. The court said, sorry, we only deal with government entities. So previously judicial review was seen to be being used to control government entities only. Now it applies across, and this has been said many times by decisions from many times, and rightly so, by decisions from the High Court and other courts. And the whole thinking here is that we are all bound by the Constitution, we are all bound to respect human rights. The other way in which the Constitution has changed the outlook to judicial review is in the manner of approach. For a long time, we relied only on the common law approach of, first of all, seeking leave of the court before filing the notices and so on.
So that is a procedural...
that is a very useful procedural change that has been brought about.
Now, just on that particular issue, there are those, put it this way, part of, and this is usually referred to, I don't know, constitutionalization of judicial review. Since Article 47 came in, and then we have the Constitution, and we still maintain the common law, what problems do you see going into the future resulting from these varied channels of judicial review? Or is it, first of all, is it a problem? And if so, why not? Or if it's a problem, can you tell us why?
I want to say that it is a problem to the extent that it is a bit confusing to the practitioners. One may not know exactly when to approach the court by way of petition directly or by way of seeking leave of the court, the common law approach of judicial review. That area needs to be straightened. It is not very clear to practitioners out there, and more so to the litigants out there. But then Article 47, together with the enabling statute, the Fair Administrative Action Act, they outline clearly, I mean, the main focus is that other alternative remedies should be sought before approaching the court where they are available and if they are effective.
Okay. So you have no problem with the existence of various streams of judicial review or administrative action?
I don't see a problem with that, and maybe my lack of seeing the problem is the transition, kind of what I would call the transitionary phase in which we are from the older ways of doing things to the newer ways.
Okay. Now, you have been involved in sports, and I think and in part of your readings I see some of the issues you have raised. We have the Sports Tribunal. The Sports Tribunal, and it is created under the Sports Act, isn't it?
Yes, Section 55.
Section 55. Now, is there a right of appeal? Is there a right of appeal against a decision of the Sports Tribunal?
Thank you, Honorable Commissioner. There is a right of appeal, but two tracks. If the dispute at the Sports Tribunal involves sports bodies, after the Sports Tribunal, the next port of appeal is the Court of Arbitration for Sport. And this is laid out in the international statutes of those sports bodies. They don't want their matters held up in courts.
Okay. So I just want to say, so you agree that under Section 55, there is no right of appeal to the High Court or to the ELRC or to the Court of Appeal or the Supreme Court?
Honorable Commissioner, I had not finished.
No, I don't. I am just asking a specific question.
No, there is a right of appeal.
Under Section 55?
Section 55 may not specify that. It doesn't specify that.
So if a statute does not specify a right of appeal, like Section 55, is there a right of appeal to the superior courts? Yes.
And I would say yes, because there's an article I'm not remembering very well, but we are all entitled to justice, and justice here demands that we be able to exploit all avenues of dispute resolution available, and most available under the Constitution.
Okay.
And under the Constitution, tribunals are classified under subordinate courts. That makes it already a route to go higher in terms of appeals.
So despite the fact that there is no right of appeal in Section 55, you can still go to the higher court. Okay. So the other issue is that the tribunal has a special jurisdiction under the Anti-Doping Act. And in that jurisdiction, the right of appeal there is to the Court of Arbitration for Sports. If you are dissatisfied, you go to the Court of Arbitration for Sports. Now I want to ask you, where is this Court of Arbitration for Sports located? Or it's virtual? I don't know. You tell us.
Honorable Commissioner, the Court of Arbitration for Sport is physical and located in Lucerne.
Okay. Lucerne, that is in
Switzerland. Yes.
Okay. Now, if you are an athlete in Kenya, say you are from a village called Cheptongei in Marakwet, and you have a small dispute, and for whatever dispute, it means if you are dissatisfied with our local tribunal, the statute forces you to go to Switzerland if you want to appeal. Now, under Article 48, what is the state obligation in terms of ensuring your access to justice? You are from Cheptongei, you cannot afford 10,000 USD to lodge an appeal. What is the state obligation to ensure the access to justice in such situations?
The state obligation is to avail the necessary legal and institutional fora which are availed. However, with respect to sports persons, these are also governed by the international rules. Under the international rules, there is an attempt to subject sports persons to uniform law globally. And this is why an appeal will then lie to the Court of Arbitration for Sport. That is number one. Number two, in matters doping, the World Anti-Doping Agency has a stake. The international bodies are interested. They cannot come to file an appeal in a local court.
So the issue I'm asking, if I'm a poor Kenyan, the state has given away my right to access to justice. So the issue I'm asking is, what is the obligation? Because the state, this is a fundamental right of access to justice, that I am dissatisfied with a local tribunal, but you are telling me to go to Lausanne. So what is the state obligation, and how is it promoted, protected, fulfilled? So you tell me, because you were involved in the drafting, what did you contemplate that the right of any person who is aggrieved will be protected, promoted, fulfilled in terms of telling me to go to Switzerland. How was that to be achieved?
That was to be achieved, first of all, through the understanding that sport and participation in sport is a private affair. It's a matter of choice. One chooses, one does not choose. In terms of state obligations to facilitate, I'm not aware of any. We did not think about that at all. All we contemplated, and what is contemplated, is that a person has freely chosen to participate in this. Now the person has an obligation to obey the rules of that sport, and under one of those rules is to appeal to Lucerne, not locally.
I don't want to flog the horse. This is now a statutory provision. You know, it would be different if there was no statutory provision.
Oh, yeah.
It would be different that it's just me and the Boxing Federation or the athletics, and we have our dispute. But now, the state, my state, is telling me to go to Lucerne. So isn't there an obligation on the state, which you as the one of the drafters of this ought to have borne in mind in terms of promoting, facilitating, protecting that right, Article 21, in respect of this?
I think there is an obligation of the state, but then the obligation would take the nature of the state availing, say, counsel for the purpose.
Okay. Now, just on the same issue of administrative law, we have been told many times that judicial review deals with the process and not merits. I think that is general. But there are circumstances where the court may delve into the merits under judicial review. Are there such circumstances?
I would say the main purpose is actually to interrogate the process. But in interrogating the process and arriving at a final decision, that could appear like the merits have been dealt with.
Okay. And just on that particular issue, one important administrative intervention in Kenya has been the establishment of the Office of the Ombudsperson, that is encapsulated in the Commission for Administrative Justice, one of the hallmarks of good administration, and to be able to resolve citizens' grievances and to subject public bodies to a certain standard of administrative behavior. Do you know what is the latest decision by the Supreme Court on this particular issue of the Ombudsperson, of the Office of the Ombudsman?
Yes, that is the matter of Vision 2030.
Yes,
versus the Commission on Administrative Justice. Yeah.
You've read the decision?
Yes, I have.
You have read the decision. And this I want to ask you because it's just an issue of adjudication. In that decision, the court gave certain guidelines. It gave certain guidelines, am I correct? Regarding the nature of the decision.
Yeah.
It gave certain guidelines. And you have read other decisions of the Supreme Court where it gives guidelines. From a point of view of development of jurisprudence, in your view, is that a good approach to give guidelines or to deal with a specific case? You tell us in terms of development of jurisprudence as an apex court.
In terms of development of jurisprudence, it is good to do both. Maybe not in the same matter. Now, in terms of giving guidelines, these guidelines eventually guide other courts in resolving similar disputes. So jurisprudentially, I would not fold the approach of giving guidelines in decisions the way the Supreme Court has done in that one and in several other decisions. Now, you raised the question, what about just dealing with the dispute itself? Of course, it is in the process of dealing with the dispute that then a bigger picture emerges that then requires some kind of guidelines, and this is also in light of what I had been asked earlier, whether judges make law. Through the giving of those guidelines, they assist other courts. So I see nothing wrong with that.
Okay. I'm sure you have been watching these interviews from day one.
Your Honor, I'm not sure whether you are making a statement of fact or presumption.
I'm just asking you. You are the second last candidate, so you have been watching the interviews, and you know what kind of questions will be asked, just the way we used to read past papers, and we try to answer them. So I just want to ask you, because we've asked everybody on the Muruatetu case, you know the Muruatetu case, and we've discussed it with the other candidates, the Muruatetu case. One of the issues that has come up, and I just want to hear your view on this, is that you know what the case was about, the mandatory nature of the death penalty, and there are those who have said it has had certain consequences. For example, what consequences has that had on other areas of law in Muruatetu? The court said the mandatory death sentence is unconstitutional. So what other consequences has that had on other areas of law?
Yeah, we have other statutes where there had been where maximum sentences had been prescribed in the law. For example, in the Sexual Offences Act, the Muruatetu decision has had an effect on that, and now judicial officers are applying that decision in those and in similar cases where a maximum sentence is prescribed by law.
In your own view, do you think that is a good thing, or you think the superior and subordinate courts got it wrong?
The main argument to me is very persuasive. That is to say, if we just say this the maximum sentence, then that takes away the discretion of a judicial officer to consider any mitigating circumstances. And that kind of puts all crimes by one name in the same basket when they may not all be the same. So I think that taking of that, to me, is good, and it's helping our people. It has freed the hands of judicial officers.
Okay. So there are those who say that, in fact, the court should have said that this principle, is limited to this case only, and it should not be followed in any other case. What do you think? Do you think that is a problem for an apex court to say so? Say, we have heard you, Muruatetu, we agree with you, but this principle is only applicable to this case. As an apex court, do you think that is a proper approach to dealing with that kind of an issue? To make it very clear in that sense.
Honorable Commissioner, one of the obligations of the apex court is to establish jurisprudence, set the law to be followed. Now, in a situation where the court would say, we have looked at all this, but this applies only here, that would leave a lot of open gaps, and that will not be good guidance to the other courts, especially the courts below.
Okay. On to another area. You are a dean of a law school in a church-affiliated in a church-affiliated university. In fact, this is I'm told, and correct me if I'm wrong, you start your classes with morning devotion. Am I right?
Yeah, we pray, yes.
You pray. Now, if I were a Hindu or a Muslim or any other religion, do you see that as a problem for a university that is public in nature?
Yes, that would be a problem if the university or such a university compels those of other faiths to adhere to that. Let me also mention that I have worked at Catholic University, which is also faith-based, and we had students from all over. At Daystar, in fact, the majority will not be here. We have quite a number of students who profess the Muslim faith.
Okay. So you are familiar with the decision of the Supreme Court in the Fugicha case? The hijab case?
Yes, but let me also say that I liked the one of the Court of Appeal better.
You liked the one of the Court of Appeal better. So there are two issues. If you are on, there are two ways you can look at it. In your view, let's put it this way: the majority of the majority of the Supreme Court took a narrow view of the matter, adopted a formal view, isn't it? You can say it adopted a formal view. If you are seated in that court, where would you fall and why?
Now, that is also a tricky question, because the matters in Fugicha are not yet settled.
No, the Supreme Court matter is settled. So just tell me, I'm not even telling you about the substance. Where would you fall and why?
Okay, now, I would want to fall on the side that considered Article 159(2), where's that 2C, where one is supposed to look at matters without giving undue regard to technicalities. My challenge with that decision is one of focusing on the technicalities of Fugicha not having been a party right from the beginning.
Okay. And my final question is, what is the CJ's, the Chief Justice's role in university education? You have been involved in legal education. What is the Chief Justice's role in in university legal education?
To admit the products after they have done their 5-6 years as advocates.
Yeah, the Chief Justice has no role in Council for Legal Education or Kenya School of Law?
The Judiciary, the Judiciary is represented on the Council of Legal Education, yes.
So what is the role of the Chief Justice?
That would be more advisory. Yeah.
And as a Chief Justice, how would you use your position, and I can see you have also litigated on some of those issues, how would you use your position to influence legal education in Kenya, yourself as a Chief Justice?
Yes, Honorable Commissioner. As CJ, I will do several things. Number one, through the membership of the legal, on the Legal Council of Education, ensure that the laws, the rules that guide the process of graduation, admission as an advocate, training as an advocate, examinations as an advocate, and eventual graduation are actually smooth flowing to minimize the avalanche of cases we have had in the High Court touching on that. That's number one. Number two, I would want to build networks with the deans of those schools for purposes of having the judiciary have a presence in those schools. As had indicated earlier, I would want all judicial officers who have higher qualifications to adopt at least a university as part of their community service. Offer one class. And then, of course, thirdly, I would want to use the university to propagate some of the work that is done by the judiciary. I hinted at the various moot court rooms, wonderful, very expensive, but which are largely lying idle. If we can use them to kind of stage plays there on various aspects of the law and eventually broadcast this to the public, we'll be able to reach the public through the universities.
Okay. One final question, and this is a scenario. Somebody has a, say, in your neighbor in Nambacha has trespassed on your land, or your brother's land. Your brother sues the other person for trespass, and in the process he says, in the pleading he says, X has trespassed on my land and therefore caused me loss and damage and interfered with my right to land under Article 40 of the Constitution. When the magistrate hears the matter, the magistrate says, well, it's okay, I hold that there has been trespass, and that trespass amounts to a violation of Article 40. Matter goes to the Court of Appeal. The other person is dissatisfied. High Court, magistrate is upheld, says the magistrate is right. Goes to the Court of Appeal. Court of Appeal says magistrate was right. The case comes to the Supreme Court, and the issue of jurisdiction arises. One party says the court has no jurisdiction. The other party says the court has jurisdiction. Where would you fall seated in that case? Of course, not disqualifying yourself, but where would you deal with the issue? How would you deal with the issue of jurisdiction of the Supreme Court?
Thank you, Honorable Commissioner. The Supreme Court has jurisdiction to hear appeals as of right where a matter of violation of the Constitution or of rights is involved. So that is already in black and white, and I wouldn't have an issue with that at all, especially if one is alleging violation of Article 40.
So in this particular case, you would be saying that merely because the person said it is trespass and therefore a violation of property rights, the court would have jurisdiction.
Honorable Commissioner, I am saying that if the purpose for appeal is based on the rights or violation of a right, then the court will have jurisdiction to hear it.
So in many instances where we interact with government bodies, there is a violation of a right, isn't it? Many instances, even when you are an employer, even when you are an employer-employee, you've been wrongly terminated. It is a case for wrongful termination, and in your pleadings you say, I was wrongfully terminated, I need my damages, but it is also a violation of Article, is it 40, I think 41 or something, about my fair labor rights. Does that per se mean that it is a matter that will go up to the Supreme Court and the Supreme Court will accept that it is actually a matter of fundamental rights and freedoms?
Honorable Commissioner, just the fact of having been dismissed may not be a matter of rights. The right should have been pleaded right from the beginning. So, where from the initial pleadings, that violation of that or related rights is pleaded.
So, you are advising Kenyans that in every case you file, whether it's an accident, please plead a violation of a constitutional right because the Supreme Court will take your case. Is that a fair assessment of what you're telling me?
Honorable Commissioner, I cannot be heard to be telling Kenyans that because when Kenyans approach a court, they want an immediate resolution of their dispute, and the focus is finish with us now. They are not looking at the long trail of appeals. However, if parties are dissatisfied and they keep hopping from one court to the next, then the Supreme Court has jurisdiction only in certain instances. And where then one alleges a violation of a right, then that allegation should have been pleaded right from the beginning.
Thank you very much, Professor. Thank you, Chair.
Thank you very much, Honorable Judge Majaja. Thank you, Professor. I think I'll allow one more set of questions from Honorable Commissioner Macharia Jeru, and then we'll take a break. Honorable Macharia.
Okay, thank you, Prof. Let's proceed from where my colleague, Commissioner Majaja, has left. Owners of motor vessel Lillian S. versus Caltex Oil, 1989. Now, tell us what is famous about that decision, so that I can move now to my next set of questions.
Thank you, Honorable Commissioner. I think in that case, we only recite a very small part of it, attributed to the late Justice Nyarangi, namely that jurisdiction is everything.
Yes. Now, arising from that fact that jurisdiction is everything, there is a tendency sometimes of judges, when that issue is raised of jurisdiction, to say that yes, you've raised it, but there are also other issues in your matter. Let's deal with all the issues, then I'll make one decision. Now, what is your position regarding that? And if you are a judge, how, if you are to be the Supreme Court, how would you deal with it?
Yes, very difficult question. I've seen those decisions. I think it's also a matter of judicial economy. I think the court would be saying, okay, you have raised this, but then you have also raised other issues over which we have jurisdiction. Why don't we handle all this in one, at once? There are other matters which are so clear-cut, or in which a court will clearly see that it has no jurisdiction, and there, as the late Justice Nyarangi advised, the court should lay down its tools.
Yeah, which is why I'm asking if there are matters that are so clear the court has no jurisdiction, then why not deal with them and separate so that you're able now to argue the other issues? I'm just trying to understand now for you, if you are the Supreme Court and the issue of jurisdiction is raised. You are in the Supreme Court and now you're the President of the Supreme Court. So why would you want to combine all the arguments when you have an opportunity to separate, to sift, as it were, it's like sieving. So what would be your position regarding that, bearing in mind what the late Justice Nyarangi stated in that matter?
Honorable Commissioner, I will take a more strictest approach. If I notice that the court has no jurisdiction, we just lay down our tools.
But you've also provided for a scenario where it may have jurisdiction in some, it may not have in other issues. So how do you deal with that kind of scenario?
No, Honorable Commissioner, I was referring to what has happened before at the Supreme Court. If there's no jurisdiction, there's no jurisdiction, the matter stops there.
Okay. Now, let's leave there, and we move now to the issue of your CV, because I've also looked at it. It's quite extensive. Now, I noticed that you wear more or less two hats. There's the sports bit of it, physical education. There's the legal. Now, which one is your greatest strength in the two? Where have you been more vis-a-vis the other? When you look backward to your career.
Honorable Commissioner, let's not talk about strength. You see, the computers we use have a CPU that famously stores information in specified files, folders, and so on. The human brain has files and folders that intermingle information. So, I cannot say I'm stronger here or stronger there. They are not two separate. I'm able to mix the two comfortably.
No, I'm not doubting that. Prof.
Yeah.
I'm using your words. You say that even when you deal with people, when you've been in situations, you look at their strength.
Yes.
That's what you said. So, I'm picking now from there and now asking you the same question you ask others that you deal with. So, you have a lot of experience in physical education. You also have in law. So I'm pushing back the question now to you. Where is your strength when you consider the two?
Then I would want to answer it using the earlier version. Where have you spent more time? I have spent, I think, more time in the law part than in the physical education.
Now, because when I was looking at the universities that you've taught more, it seems like it's more on a physical education. When I try to extrapolate, vis-a-vis the law, there's nothing wrong with having both. I'm not disputing that. It's actually another advantage, but I'm just trying to distill the information. So if we were to look at in terms of teachings, now from your scholarly work, it seems to me even the papers and everything, it's more on a physical education. Would I be right on that?
Honorable Commissioner, you would not be right in that, in the sense that looking at the papers, I followed the courses of studies in each of those disciplines from beginning to end. So, taking that approach, I'm eminently qualified in both. In terms of what you're asking about the teaching, I last taught physical education, strictly speaking, in 1998 when I was at the University of Namibia. Namibia, that was 1 year, Botswana 2 years. I had been at Kenyatta University for 13 years. That makes 15 years.
15 years.
So I have spent about equal time in both areas.
Yeah, when did you start teaching law?
In 2010.
2010. So now 2010 up to now, It's about
Oh,
11.
Yeah, sorry, the teaching, yes, I was combining with the practice.
Yeah, that's why I'm saying that the teaching, you've taught more of physical education than the law. Now again, when it comes now to practice, I was looking at when you became an advocate, and you became an advocate. Now you're approaching, say, 16 years of
I think practice? I'm approaching 17, not 16. I'm already done 16.
Yeah, 16, yes. So it's 16 now. So I was basically seeing again, it's like borderline because the qualification of a Supreme Court judge, Chief Justice, 15, right? So again, borderline. Now, bringing me to this question now. You see, and I'm not underestimating you are eminently qualified. I have absolutely no doubt about that. But you see, we have to compare, of course, also with the other candidates, because ultimately, when you pick that Chief Justice, we must account to the people of Kenya. This is not a position even us as JSC can just dish out as we wish. We must be able to account to the public. So now tell me, in comparison with the others who are also seeking the position, the same position, now tell us what is it that you have that you think in comparison with the others puts you a notch higher than them in terms of bringing in transformation in this judiciary, both in terms of experience, in terms of vision. And you see, all this is the issue of burden of proof. You prove by what you've done before, bearing in mind the fact that when people are being interviewed, they can say anything, but we look at their background, what they have in the past, that actually proves that going forward, yes, this is the person. So I don't know whether you could be able to distill that and tell us.
Yes. One of the things that I think I bring on the table very strongly is one of leadership. I have been manager for Special Olympics International in charge of Africa from 1999 December to 2001. In that role, I worked with very many sub-Saharan countries, oscillating between ministerial offices and the sports bodies in the individual countries, doing a lot of diplomacy. I have worked on a voluntary basis at the National Committee of Bioethics of NACOSTI for 6 years as vice chair. I want this commission to know that at the time I got to NACOSTI, about 2011, where the country was having certain challenges. For example, in 1992, a researcher from Kenyatta University, in collaboration with some from the UK, did research using materials from Lake Bogoria, extracted some extremophiles, the specialized enzymes for bleaching genes. The fellows out there went and patented, ran with it. All the bleached genes we see around here, the materials came from Lake Bogoria, but Kenyatta University got nothing out of that. When eventually it dawned on the university and it started making a little noise, the company equipped the biochemistry lab with computers. And it has now pledged to give 3 million shillings to the community and Roy's community around the lake. We lost out on that. Getting closer to now 2002, 2003, we had this challenge of HIV and AIDS. And one of the methods being propagated for preventing HIV and AIDS was male circumcision. Honorable Commissioners, in the process of pushing that agenda, somebody disappeared with 42 foreskins of Kenyans without their permission, without the knowledge of the government, without anything. While I'm still on, so arising from that, while at NACOSTI, we decided to address that problem, that challenge. And what did we do? We developed rules and guidelines for what we call material transfer agreements. So any researchers coming into the country and wanting to do research involving carrying out our materials, they must go through certain protocols so that as a country, we do not lose out. While at NACOSTI, Honorable Commissioners, we had a challenge with evaluation of ethical research projects. At the time, only Kenyatta National Hospital, KEMRI, and the Moi Teaching and Referral Hospitals had the capacity to clear ethical research. We developed rules for clearance of ethical projects. We developed rules for accrediting other institutions to put them in that position to clear research applications. And by the time I left, we had now set up about 30 what we call institutional ethics review committees. This means, in practical terms, that a researcher based in Mombasa doesn't have to travel to Nairobi to get ethical clearance. That can be done over there. Still on the question of while at NACOSTI, we worked on materials transfer agreements. That is a big relief to the country. We have expanded the manner of ethical review of research. That was a very big concern. And we have also kind of set out what is called operating manuals. So each committee knows what to follow in all standard operating procedures. So each committee knows exactly what to follow in the process of doing that. And we have made it quite easy for researchers. Honorable Commissioners, allow me also to mention something. In the 80s and 90s, for those who may remember, and even early 2000, if AFC Leopards was playing Goromaya at Nyayo City Stadium or Kasarani, the city center would be a no-go zone because of rioting and the mayhem that they usually left behind. From 2006, I became chair of the Kenya Premier League Disciplinary Committee, something I did for a number of years. And together with my colleagues on that committee, we agreed we were going to apply the rules fairly and strictly. I want to report here that we did punish those clubs fairly. The clubs realized that hooliganism does not help them. And with the support of the club leaders and so on, I can say we were able to change the culture. At the moment, even if AFC and Goromaya are playing at the stadium, people are able to go about their lives freely and without fear. Honorable Commissioners, that was a transformation. While we are still at that, when I became CEO of Kenya Football Federation, a post I held for a very short time, I found there a culture of corruption. Referees, each country is expected to nominate 20 people to participate internationally, meaning they are assigned duties in other countries, they get allowances, stay in 5-star hotels, very comfortable kind of thing, a very much envied thing. The practice then was that these referees were expected to bribe, number one, fellow officials, of referees officials, and then the bosses of KFF. I abolished that. And the practical way I did it was to just I would invite the officials of the referees, tell them, sit in that room, you have 2 hours, give me the list. As soon as I get the list, I forward it to Cairo. So I have that method to deal with corruption. Now,
try to, so that I can move to the next question, try to summarize, please, if you don't mind.
Yeah, I could just stop there so that we see if we can capture that in the
now,
next question.
See, looking at all that, all of it is touching on sports, research, interlinking sports and all that. talked about Kenya Premier League, which you may or you may not be aware, I'm the one actually who registered it, set up all those rules, including that committee you're talking about, including even, your appointment, and all those things. All of them sports related, largely. Let's move to legal. So that, because see what I'm trying to do is to match your skills with the job that you're seeking, considering that it's a high profile job. Let's go to legal, and you tell me now as a practicing advocate, you give me 3 major cases that have had an impact on development of jurisprudence. 3 major cases, again very briefly, that have had impact on jurisprudence, so that we can trust that Professor Moni, we're not taking a specialist in physical education to the Supreme Court and become the Chief Justice. We're also taking somebody who has vast knowledge in a law and will be the leader of jurisprudence in that court.
Very well. The first one I want to point at, and which shaped the direction that other courts took, and therefore the jurisprudence, was the Odinga case of 2017. Having been decided within that stipulated time, now the other courts had no choice but to follow.
No, Prof. I'm saying a case that you have handled,
Oh, I have handled.
Professor, not
yes, sorry.
The case that Professor Moni Wekesa has handled, that has had major impact on development of jurisprudence. You just give me three cases. Now that we've left the physical education, you've given a lot of achievement, and I agree. I have no doubt, I have no doubt you are an authority in sports, and that's why actually in Kenya Premier League, when you develop the rules, we chose you. I'm the secretary to date of the Kenya Premier League Limited, so I know why we chose you and not anybody else. Now I'm looking now for the legal strength, so that you can know, because we're not looking for a Chief Justice for physical education. It's also be a leader of jurisprudence. So you give me 3 cases that you've handled that have had a major impact on development of jurisprudence in the Republic of Kenya.
Thank you, Honorable Chair. Most of my cases have ended up at the High Court. I cannot really say they have had a major impact on the jurisprudence in Kenya.
Yeah. Now, okay, that's all right. I'll not pursue that point any further. Now, what I noted is that you've also had a stint on a political seat 3 times, actually 2007, 2013, and 2017. And 2007, I think it was Labour Party. 2013 was a United Democratic Party. 2017 as an independent. And I must congratulate you for giving it a try again and again. That's a mark of resilience, in my view. Now, but again, there's also a downside to it, because if you are moving from one party to the other, it may also mean that you don't have an ideology. And why I'm saying that, because then it means that you may also be lacking a philosophy that guides your thinking in terms of, when it comes to the legal jurisprudence. Because see, if you look at all the judges, in fact, the famous judges that we even quote, say for instance, like Lord Denning, you can see the flow of the thinking of Lord Denning, Now, if you are lacking in a philosophy that guides you, that could also be a danger. Now again, looking, as I said, this burden of proof, I'm looking at your past. So convince me that you have a legal philosophy, tell me what it is, and why you have, what guides that philosophy.
Very well. Let me start backwards. In terms of political parties, we live in this country, and we know that we haven't yet matured politically to really talk about principles. We talk about congregations of willing partners. So it would be extremely harsh to be charged along those lines. Having said that, we have learned very many legal philosophies. My experience is that one applies a legal philosophy to a specific case depending on the facts and circumstances at that point. Generally speaking, I like the sociological school of law. The sociological school of law posits that one needs to understand the society for which the laws are being made. One needs to understand why the laws are being obeyed or disobeyed. One needs to understand the people in that society in order to be able to make appropriate laws. And in fact, here Eugene Ehrlich says, yes, if you want to know whether the Factories Act is working, don't look at the black letter of the word. Go to the factory, see how it is working. Now, with that philosophy, and remembering where I started, this is why I believe that so far, the judiciary has confined itself to a certain space. It has not moved to where the people are. And using that philosophy, I would want administratively to move the judiciary to where the people are, so that as they use the laws, as they partake of the judicial services, they are doing something that they can flow with. In terms of jurisprudence in court, all these laws, all these disputes that come will have a social bearing. When we talk about a case that has made an impact, we are talking about a case that has a significant impact on the society. And that's where now I say there are many schools I subscribe to.
Prof, with respect, what I've heard is more of political statements with generalities, not concise in terms of how your thought would flow, with tremendous respect. And now, you mentioned something that just crossed my mind, where you say that our politics, there are no principles, there are all this, which means that you're explaining why, you opt from one party to the other. But see, that concerns me, Professor, because, we are not looking for an ordinary thinker or somebody who flows with the, behavior of people in terms of how they conduct their politics. We are looking for this principled person who is able to provide a direction. This is the embodiment. This is the face of the judiciary. This is somebody who will be identified also with the development of the jurisprudence up there that could shape how the country moves. Now, if you are ordinary, just like the other guys who are fighting for those political seats and who are changing, as it were, depending on the circumstances you are saying. Now, how then can we trust you as our Chief Justice to provide clear direction based on sound principles?
This is how. Where I serve on the international tribunals, we apply the law and nothing but the law. In my academic writings, I've written about the law and nothing about the law. I am very focused. I can focus on the task and deal with the task at hand. I said it would be very unfair for me to be judged on account of what one is calling moving from one party to the other. However, even that movement from one party to the other has also taught me how to deal with politicians. And here, politicians are useful in availing resources to the judiciary, in helping the judiciary in other ways. I bring in that aspect. C.B. Madan, we adore him. Al Warren, we remember him. These were people who served in political offices at some point or other. I was not lucky to succeed in getting there, but I understand the mind of a politician, and I can engage them as CJ for the benefit of the judiciary.
Forgive me, Prof, if I give you an impression I'm condemning you. I would never do that. I would not even judge you. It's just that, as I said, I'm trying to match the skills and the person vis-a-vis the position so that we can account to the people of Kenya. But I respect what you've done, and I acknowledge that. But which takes me now to the last thing that you said about how you've served in the tribunals, how you've applied the law, and all that. Kenya Rugby Union, of course you are aware about their complaint against which was served to you and which you responded to. But they are accusing you of not actually following the law. Because if you look at what they are saying, is that you are appointed to a Kenya anti-doping task force. And while serving in this task force where you are the chair, you went ahead and firstly never even give them an opportunity to be heard. The rules of, you breached the rules of natural justice, and did your investigations, and then named the coaches and players where you said that that they were using banned substances. In fact, they say in their complaint that you went ahead and in some, and mentioning names of coaches of international repute in libelous fashion, that in pages 40 and 41 of your report, you stated that they were using food supplements that were banned, that were contravening both World Rugby and KFU regulations, and basically saying that they were enhancing, what was banned is what they were using that was leading to them performing the way they were performing. And there was a hue and cry, the whole public, media, and all that. And you actually you made spirited attempts to justify, and to continue, as it were, to rub salt in the wound, condemning them, alive to the fact, the fact that rugby sevens, it's one of those sports that have really catapulted, the name of Kenya in the global arena. But that notwithstanding, you still went ahead and did what you did without giving them an opportunity to be heard. Now, the World Now organization, when it came later and did now a very comprehensive, the World Rugby Anti-Doping Advisory Committee member, Mr. Gregor Nicholson, came, took 2 years, did a thorough job, and it was found that you are actually wrong, essentially vindicating them. But you can imagine now they are being vindicated after a lot of damage has been done. So I don't know what you would say about that, because that seems now to contradict what you just said about being in this international organization where, and bodies where you've been able to actually do very well in terms of proving that you can be fair, you can be just, you can be equitable, and all that. And remember, now you'll be going to be the Chief Justice, where you're expected actually to be an embodiment of fairness, application of rules of natural justice. I don't know what you would say about that.
Yeah, thank you, Honorable Commissioner. At the time I took over, I was appointed to the task force. A total of 34 Kenyans had tested positive for banned substances, including a rugby player, a football player, and so on. That is well documented in Appendix 1 of the report, which was submitted by Mr. Kankla, which I also submitted. In carrying out our investigations, we took a three-pronged approach. Number one, we contracted researchers from Kenyatta University to carry out an empirical research. They went out to rugby, to players, not just rugby, we're dealing with all sports. They recruited 1,500 in their sample. They used a questionnaire. Out of that, 1,365 returned filled questionnaires, giving it a 93% return quota. Of the 1,365, 226 were rugby players. There was then the question put to them: do you know anybody who uses prohibited substances? 78 of them said yes. It's in chapter 3. Then we went the question went further. Do you know what they use? And the answer was about 75% said yes, they use steroids. We were brought that report. So, and there were reports about others also. So specific now to rugby, we were told, yes, they use prohibited substances, they use steroids. That was one track. The other track is we conducted interviews. Number one, we invited all Kenyans to come and make presentations. And a number of rugby coaches came and made their presentations. I have furnished the commission with the detailed daily reports. We wrote to the chairman of Kenya Rugby Union on 16th of December, asking him to come and explain to us several things, including policy issues. As we did that, their official, the one in charge of programs, had appeared before us on 4th of December and told us the things they do there, including giving some things to players.
This is NTV. It's one platform where everybody has a voice.
If we don't have jobs, if we don't have money, if our business...
Hosted by the King of Wit.
Do you know the Bible to that much detail? Ama hizi ni zile tu zinaendanishana na dhambi zenye unajua.
It's basically everybody's show.
Vitamin C ni cassava, shauri ya nguvu. Vitamin D ni dania.
Na chakula anaimba. I have decided.
The Wicked Edition with Dr. King Ori and the Guesswork CEO, Kenya Jui.
The Kisumu County Assembly specializes in stimulants, to be specific, concentrated coffee.
Where humor meets sense.
Moses Kuri alinitwanga hapa serious.
Soldiers wanakuanga wameka polisi kids. Mbona nyinyi mkimbiangi mkituona?
The Wicked Edition. Every Friday at 7:30 p.m. only on NTV.
The Kuza Awards are here. This year's theme is Preserving Our Heritage Through Broadcasting. Vote for your favorite channel NTV for the People's Choice Award. To vote for the People's Choice Awards, SMS the word Kuza, that is Kuza, to 15601. Answer the 5 simple questions and press send. This text message is absolutely free. Voting ends on 23rd April 2021. Vote NTV, turning on your world for the People's Choice Awards.
They recognize that there is no wall that you can build that can keep the enemy away from you if God doesn't keep you safe. And that's a big lesson for us.
Mboga mboga mboga. Mboga mboga mboga. Managu. Mchicha. Sukuma. Mchele.
Mboga.
Mchele. Mchele. Kwani mchele ni ukali?
Hapana.
Mchele ni nini?
Ni mboga.
Mboga mboga mboga. Mchele.
Mboga.
Managu.
To get Mboka, dial *811 *929#. Skiza na Nation.
The free got it from Montreal. His name is
games with at least 30 as Zion slams it down.
Yeah, we mentioned the ferocity with which he slams.
And the three-pointer, Boucher.
How do you say shake and bake in French, Manny?
Trent has it denied by Bukashevsky. Ahead now.
Hanging forever.
Oh my, Chemezi Metu. That got his team.
Oh! My mind is blown! Oh, how about that play by Noel? And he's hurt.
Oh, that'll keep momentum on your side. That's why you keep a Martin on the floor at all times.
Big finish from Carl Anthony Towns.
Dade County, how do you like Bam, man?
Make is the bribes.
Get 500 MB free kila siku and never miss a moment.
Did you know you can take up a funeral insurance, also known as a last expense, for your loved ones? Consider taking a funeral cover to avoid unnecessary stress and fundraisings when you lose a loved one. This policy covers funeral-related expenses such as burial fees, transportation costs, and grave preparation. Now you know. IRA, promoting insurance, protecting the insured.
If there's one thing that all soaps do, it's wash. From buckets to basins, bathrooms to streams, and everything in between.
All soaps wash.
Yes, but Protex is different. Its reinvented formula with flaxseed oil boosts your skin's natural anti-germ defenses by 10 times more, protecting you against 99.9% of germs. So what keeps us healthy?
Protex.
Protex. Good health starts here.
This is NTV.
The author commissioned by World Rugby says yes, they received this report on the 22nd of 22nd of October 2014 from the World Anti-Doping Agency with a request to follow up on the recommendations. Our main recommendation was subject them to a disciplinary process. From there, it was now up to World Rugby to verify whatever we had found and then see whether they need to be disciplined or not. And World Rugby did that.
In fact, you just preempted what I was going to come to, that the World Rugby's specific focus was whether there was any evidence to suggest that an anti-doping rule violation had occurred. And on March 10th, 2016, 2 years after your report, the Nicholson Committee, this is now the World Rugby one, cleared Kenya Rugby of all allegations. Isn't it? They cleared them completely. But you see now, clearing them, yes, but you'd already condemned them and had. That's the point that I was trying to indicate, that 2 years later they are cleared. But you can imagine the anguish they go through, which is now why I'm worried that if you became now the Chief Justice, because it's a quality about drawing conclusions, rushing to judgment without giving an opportunity to somebody to be heard. That's the point that I'm trying to address. Considering that this is going to be a Chief Justice Prof. Moni Wekesa. That's my worry. But as a last point on this issue that we can close the matter. Now, at the time when you're doing that research or investigations, now, the only accredited WADA laboratory in Kenya, in Africa, was only one, isn't it? The only accredited laboratory, WADA accredited laboratory. Where was it?
At the Free University in Bloemfontein.
Exactly. Now, so the samples that you used, which laboratory did you send them to?
Yes, the laboratory we sent them to is marked as under Appendix 6 of the report.
Which laboratory?
This is the Drug Research and Analysis Laboratory of the University of Nairobi School of Pharmacy.
Now, you see,
I'm coming to that, Honorable Chair.
Yeah.
Sorry, Honorable Commissioner.
It's because the Chair has given us very specific time. That's why you can see I'm trying to rush you.
No, it's okay. Yeah. I've seen in the complaint somebody mentioning that lab. At the time we asked that lab, they told us they don't deal with foods. I have now furnished the commission with a printout from the website which says the laboratory only handles urine and blood samples. So even at that time, that laboratory was not available. I consulted. We have an Africa representative for water based in Cape Town. I consulted him. We checked with that lab. It said it could not handle. So we used preliminary results. And I think it's also good to point out that at paragraph 16.24 of the Nicholson report, they say that yes, the task force relied on the results of the Daru lab. We do not condemn anybody unheard. We collected information from several sources. I have furnished invitation letters that went out to the chair of rugby. The complaint there is that we never invited rugby to appear. Rugby appeared in a very big way.
All right, thank you. That's all, Honorable Chair.
Thank you, Commissioner Sharia. Thank you, Professor. Commissioners, let us take a few minutes break. I will come back 5 minutes to noon. Professor, Madam Anne will come for you and take you where you can go and get some rest. Thank you.
This is NTV.
They recognize that there is no wall that you can build that can keep the enemy away from you if God doesn't keep you safe. And that's a big lesson for us.
These flags are representing the people that live in Philadelphia. That's what I'm doing.
To make it in America, you need to be focused, steady, you need to be consistent, you need to work.
My Swahili is still pretty hopeless. Jambo Bwana, Missouri Sana.
You can take an
African out of Africa, but you can't take out the African in them.
The experience in Kenya has been a great one. It's been positive. The weather is great. It's like our home city in Nigeria, which is Jos.
I watch Daring Abroad. Congratulations for what you do.
From State Farm Arena, the 2021 NBA All-Star Game.
When you're able to represent your team, your family, it's not something that I take for granted at all.
You know, who knows if I'm going to have the chance to play against them again. So enjoy the moment. We're going to try to get a win for sure.
I just love the fact that HBCUs are being highlighted.
Each quarter is like its own game, with $150,000 going to charity and then $300,000 going to the charity of the winning team.
I ain't been this close to this ever. Nice play. Here's Curry. Oh, beautiful pass. And the Joker with the bucket. Now we loose. Get the legs moving. 2-on-1. LeBron with the reverse.
Here's Curry, 3.
It's one platform where everybody has a voice.
If we don't have jobs, if we don't have money, if we're not, if our business...
Hosted by the King of Wit.
Do you know the Bible to that much detail? Ama hizi ni zile tu zinaendanishana na dhambi zenye unajua.
It's basically everybody's show.
Vitamin C ni cassava, shauri ya nguvu. Vitamin D ni dania. Ana chakula, anaimba. I have decided.
The Wicked Edition with Dr. King Ori and the Guesswork CEO, Kenya Jui.
The Kisumu County Assembly specializes in stimulants, to be specific, concentrated coffee.
Where humor meets sense.
Moses Kuri alinitwanga hapa serious.
Soldiers wanakuanga wameka polisi hivi. Mbona nyinyi mkimbiangi mkituona?
The Wicked Edition. Every Friday at 7:30 p.m. only on NTV.
NTV jioni, habari za kina, fasaha, tendeti na za kuaminika.
It's one platform where everybody has a voice.
If we don't have jobs, if we don't have money, if we're not, if our business...
Hosted by the King of Wit.
Do you know the Bible to that much detail? Ama hizi ni zile tu zinaendanishana na dhambi zenye unajua.
It's basically everybody's show.
Vitamin C ni cassava, shauri ya nguvu. Vitamin D ni dania. Ana chakula, anaimba. I have decided.
The Wicked Edition with Dr. King Ori and the Guesswork CEO, Kenya Jui.
The Kisumu County Assembly specializes in stimulants, to be specific, concentrated coffee.
Where humor meets sense.
Moses Kuri alinitwanga hapa serious.
Soldiers wanakuanga wameka polisi hivi. Mbona nyinyi mkimbiangi mkituona?
The Wicked Edition. Every Friday at 7:30 p.m. only on NTV.
Akili, 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 akili. Will you wash your hands with me? I want to wash my hands with you. Come on, I will show you what to do. Wash your hands in clean water. Wash your hands, wet them with the water. Wash your hands, now add some soap. Scrub your hands in the soap and water. Scrub above and below between the fingers too. Scrub under your nails and scrub-a-dub-a-doo. Rinse your hands in water. Rinse them clean, rinse away the soap. Dry your hands and go. Achille, why do we wash our hands?
To wash away the germs.
Achille, what are germs?
They're like tiny little bugs on your hands, and they
can make you sick.
But I don't see any germs on my hand.
That's because they're so tiny that you can't even see them.
Oh wow! I want to wash the germs away. Will you wash your hands with me, Achille?
Of course!
The CA Kuza Broadcasting Awards is here. This year's theme is Preserving Our Heritage Through Broadcasting. Vote for your favorite radio or TV broadcaster for the Kuza People's Choice Awards. SMS the word Kuza for free to 15601. Answer the 5 questions in either English or Kiswahili and press send. Cast your vote for excellence in broadcasting. The CA Kuza Awards is an initiative of the Broadcasting Authority of Kenya. NTV, turning on your world of local entertainment.
We are so excited to color your moments this Saturday from 11 a.m. to 1 p.m. only on NTV for #TinRepublicNTV. You're going to have us, the hottest trio in town, that is Martin Kimathi, DJ Bash, and myself, for some great conversation, great music, and of course, great vibes all in all. So make sure to grab your Fanta and join us as we color our moments together. See you then.
Teen Republic, in association with Fanta.
We add color to everything, to every day and every dish, because the world needs our crazy. We're the different flavors that make life more exciting. We're the ones who add color to every moment. Fanta, color every moment.
NTV, turning on your world.
Kila uchao Seris Wafula mwenye miaka 55 hufika katika timbo la TM katika eneo la Kiambu mjini Molo kutafuta pesa ya kukidhi mahitaji ya familia yake. Mama huyu mwenye watoto 10 huhatarisha maisha yake anapokuwa milima hii ili kuokota mawe na baadaye kuyaponda.
Nilikuwa nafanya kazi ya kibarua, lakini kibarua naye unapata siku moja, siku ingine upati. Ama unaambiwa watu wametosha, sasa nikaonelea tu afadhali kukuja huku kutafuta.
Kwa siku, wanawake hao wanaweza kupokea shilingi 200 au 3 wanapouza mawe waliovunja. Hapa, wanaume ndio wanafanya kazi ngumu ya kuangusha kuta za mawe, kisha wanawake huwafuata kwa kokota mawe zilizopasuka na baadaye kuziponda ziwe kokoto. Trela moja ya kokoto huuzwa kwa shilingi 1500 ambapo inamchukua mtu mmoja muda wa wiki moja kuzipasua. Kazi hii kama kazi nyingine haikosi changamoto zake.
Mimi hata ni mara mingi huwa nimelala wodi, huwa nakunywaga paka dawa. Juu ninafikiria watoto nitawafanya nini? Saa zingine wanalala njaa, saa zingine wanafanya chochote.